Two high-profile court cases today. Legal analyst Shapiro in studio with us tonight to lend a little insight. So much to talk about and so little time. Let's start with the Brian Stow beating. The tape where Sanchez says to his mother, you know, I'm involved here. Wouldn't that make this case a slam dunk?
Not necessarily, because I'm involved could mean I was standing by, I know what was going on, I handed something to somebody else, or I should have maybe pulled somebody else back. So I'm involved just means I'm involved. It doesn't mean I messed up, I'm the one at fault here. There's a big difference. Well,
you know, a lot of people listening to this are wondering how that tape's even admissible. I mean, wasn't this a private conversation between Sanchez and his mother? I mean, I know it's not attorney-client here, but didn't he think it would have been private?
Only when somebody's Miranda rights are read to them and they say, I do not want to give any more statements, I don't want to talk to anybody without the lawyer present, until that's done, everything is fair game. And even if Miranda rights are read, it can be like unread if he picks up the phone and right in front of the police starts just making comments. As long as they're not directed to the police and somebody else, it's fair game.
Okay, the prosecution is bringing in all these witnesses at this point who are talking about what they saw just prior to the beating and what led up to it. What are they trying to do here?
They're trying to show a pattern of misconduct that led up to this event. They're trying to show that because these gentlemen were loud, disturbing during the game, that they're likely to lead up to what happened. But at the same time, this Dodger-Giants rivalry goes all the way back to the early 1900s, so I don't know how much weight that would be given by a jury.
Well, what's the defense going to say in all of this? How do you say, no, that's not the phone call? Or do you work to get that tossed out?
No, the defense could simply say like this. This man is a smart guy in terms of he has a record. He knows what's going to be used against him, what isn't. He knows better than to just shoot his mouth off and give a confession to the police. So by him saying, I was involved, it could just mean I need some help. I need, you know, someone to come and bail me out. And he said, I think I'm going down for it, which is not necessarily I did it. It's I don't believe in the criminal justice system.
There was an original suspect here. The LAPD picked him up, and eventually he did time for parole violations. But it was quite a while before they arrested these two, Norwood and Sanchez. What relevance could that bear, the fact that there was another suspect in the beginning for the defense?
The defense is going to come forward right off the bat with the jury when this goes to a trial and say, there already is reasonable doubt before this case got to trial. They thought they had the right guy. They were sure. Statements were made. And look where we are. It's a different man sitting here than there was several months ago. So you have to look at this case very carefully because it reeks with misidentification.
This is a preliminary hearing, right?
Correct.
Why have that before the trial? I mean, it sounds like the trial is in process now for people on the outside looking in. What's the difference here?
So the preliminary hearing is just where the prosecution has to prove that the charges might be true. The standard of proof is much lower than a trial. It's not beyond a reasonable doubt. It's just a reasonable suspicion. And because the burden's on the prosecution, the defense doesn't need to do anything at all. And usually the defense doesn't do anything at the preliminary hearing but cross-examine, but they don't put any witnesses. So it gives the defense a chance to test the evidence also and prepare for that trial.
You have any doubt this will go to trial?
No, I think this will go to trial.
All right, let's go to the John Edwards corruption case today. Were you surprised at all by the outcome? I mean, the jury comes in, all of a sudden says, you know, we have a verdict. They come in, actually have a verdict in one. The judge sends them back to deliberate on 5 other charges here that only after the fact we find out they're deadlocked on.
Sure, and I'll give you a little secret to what happened here. The reason why the defense, when one verdict, all they knew was we had a verdict and they were deadlocked on the others. And the defense immediately said to the judge, declare mistrial, let's go home. I suspect the defense thought that that was a guilty verdict on that count and wanted to at least try to get a mistrial on the remainders. That's why they were like, let's get out of here and go home today.
Are those jurors, will they be polled? Will we find out which way they were leaning in this?
Yes, I was actually surprised that they were not polled today. Usually it's the first thing both sides ask for is let the jury be polled. So I think that will come out at some point in the future. But Edwards' statement after the whole trial, I think that's going to be very helpful to him in terms of the prosecution and judge deciding whether we want to go through this again.
Did he become a real sympathetic figure here? I mean, it called to mind almost the Jimmy Swaggart, I have sinned. I mean, he was very contrite on the steps of the courthouse without admitting guilt.
Right, and the defense did a good job of articulating to the jury there's a difference between a sin and a crime. And you can't convict someone for a crime simply because they sinned. The second big point the defense had going for them was they had to prove not only that Edwards was involved in anything, but that he knew he was breaking the law. That is very hard to prove with these complex campaign finance laws when he's on the road campaigning for presidency. How can he know every little, penny where it's going and how it's being used?
Was there a big problem here, Andrew Young, the fact that he accepted money and lied about where it was going at one point and then only in court said, yeah, we did use some of it for ourselves?
Absolutely. And let's add to that he was given a grant of immunity by the prosecution to testify. So you have motive, immunity. What kind of credibility is a jury going to give this witness?
Where do you think this will go? Do you think the charges will be refiled and they'll drag John Edwards back in on this?
I do not. And I think it goes to the bigger picture, which is, the economy is finally turning around. There's a new presidential race coming up. I think everybody will want to just move on from this bad experience because it is a black eye on America.
How much did it help that his daughter was there with some frequency? And then when he came out on the steps, his parents were there as well.
I think it humanized him. It was important that he had the support of his daughter, even though he was not, he wasn't committed to his wife like he should have been. The fact that his daughter was there by his side, I think that did resonate with the jury.
Big day for legal beagles, isn't it?
Sure. Yeah, we woke up today.
All right. Thank you so much for coming in. We certainly appreciate it.
Always enjoy.
Take care.